Good morning, and welcome to GN Radio Legal Hour. With myself, Jones Sewa, and Abinelle Solicitors. The area of specialty for Abinelle Solicitors are immigration law and family law. If you're first time tuning in, when it comes to immigration law and family law, it's Abinelle Solicitors, all right? Today's show, if you have any questions around this area, we're more than happy for you to call in. We welcome your questions, actually. It is help yourself for maybe share wondering, and I say immigration status. Yeah, you introduce new laws be I want to sit, and I say maybe I want here lawyers are making me a fighting for a case and Sisa radio station. Maninda Heya, Maninda GN Radio in UK. So for numbers, I'll be to me after a 0203 735 8820. I mean, what's it 0203 735 8820. And that's a 0203 286 0185. Alternatively, no bet me after mobile line a 0778 793 9958 into Fred. Yeah, phone lines here. Media to Dre Fred. Na near train wide dream piano. Wait me. Ebisa na Abinelle Solicitors somewhere ha and on the plumber bow. Say a year he has to say Okoko home or more office and swat on better coin. Na wait me. During the show, the almost office line address a betuja. I also ubet me afre. Then to know. Let's begin with the show. Mini Amy Ade, then te energy chinkomo and nanope. Amy, good morning.
Morning, James. How are you?
Amy.
Hello. Hello. Can you hear me?
Yes, I can hear you. But before we begin the show, Amy, I know you had your community day over the weekend. And how was it? Of course,
Wow, the community day was a great success. So I'd like to take this opportunity to thank all the listeners and everybody who was able to attend. It was brilliant. We were able to, give back to the community with giving advice in the area of law and also in accounting and insurance as well. So it was a beautiful day, and we had quite a number of people coming in to seek advice. Thank you so much to GN Radio for all your support and to all the listeners as well. Thank you.
Good stuff. Good stuff. Good stuff. All right, now let's begin. I have a question here, and I mean, look, I encourage our listeners, Mamuti, Facebook, so share with Facebook swap, but more the answer will be share. Or any questions, be answered to me that to Facebook. Why? And I'll put it to Amy, and Amy will be able to help you. And since you know, person text, I'll be to me text. The number is 0778 793 9958. Person fresh studio hands a kwan will hold it to me a friend 0203 735 8820. That's a 0203 286 0185. Any question I want to say, but I say Ghanaian birth registration and I mean, this is what we're going to talk about: Ghanaian birth registration and child entry clearance. Name to know, make I say na lady bia me name no.
Yeah.
And omode owo ne ba wa hanom, but somebody akola no eko Ghana. Na say no person akola no eba krom ha. Akola say sia no 12 years.
Yes.
Until last time we one of our conversation, and then the Paquanica say, "Yeah, I mean, bizarre question way." In say, "Siano, acquire almost acquire bebano, and they're working on it." But in terms of say acquire binyan indefinite leave to remain, the fact say you won't wahano. A, is it possible? And B, acquire benson on befaso on me a application.
Okay. Thank you for that. So, yes, it may be possible, but it depends on the circumstances really of the case. For example, bisa say the parents no the team documents omo indefinite, and I say omo British, and I cry say omo parents omo kita limited leave to remain or krumha.
Limited leave to remain.
Limited leave to remain. Fantastic, Jones. Internet say akolano or do say ya won krumha our UK birth certificate, and no interest say indefinite automatically. On us obey British, because parents have limited leave to remain. And if before said a child no call Ghana no, not only British passport, a saw your entry clearance application. Now, with the entry clearance, no, obet me a limited leave to enter, because they are, that child is a child of a parent on no so limited leave or from her. And Jones, what is also good about this situation as well is, depending on the parent's financial situation, they can also get a fee waiver because the child would want to apply for limited leave to enter. They could get a fee waiver depending on their financial situation and whether they meet the affordability test. So definitely the child can come to the UK. There's definitely a way around it. So I think, Jones, let the person give us a call on our office line and we'll definitely be able to assist.
Okay, but I just want you to touch upon this Ghanaian birth registration and child entry clearance. And then I said,
right, Jones, this issue with Ghanaian birth certificates, it can really be a bit of an issue. When I say it can be a bit of an issue, the reason for that is, for example, now in Ghana we are doing this biometric birth certificate. So we don't have the old style, small A5 sheet of paper with written in pen that says the child was born on a particular day and time and everything with both parents' names. We have the biometric system. Now, with the biometric system, because it's just newly been introduced a couple of years ago, once you get that biometric birth certificate, the date of registration into me kind of trim one. The data on mobile register biometric biometric birth certificate no. Ebiana acquire a data, let's say for example, last month, July 2022. However, akolane be 10 years. Into some who's date of registration, the visa clearance officers, no, sometimes it's me a bit of a confusing idea bit more because it's like, okay, child maybe 10 years. I didn't have a mobile register, a mobile birth certificate. That may, it may raise some alarm bells. Is it just because upesa akolane baha into wakoji birth certificate, to suit you? Is it really true? Say akolane ye wuna sa dates no. And I say these are the questions that they constantly ask, and Jones, when they ask questions like this, we need to give them responses. I say, and so yet me responded to in some cases, no. Some parents still have the old style birth certificate, the one that is written by hand. And if you look at the Home Office guidance, what they want to see is say, the birth of the child, no, or register within 12 months of the child being born. So if the child is 10, technically, they would really want before the child's first birthday, the registration has been done. And that is a birth certificate that is accepted, by the entry clearance officer and, by the Home Office. If not, it can be quite difficult for them to believe, a difficult mom. So, say, akola with 7 years, 10 years, 11 years, afena or a birth certificate. So, Jones, that part is always a problem, for a lot of individuals, a lot of clients. It's always an issue because we now have the biometric system and it's not everybody or what the old style birth certificate. So that is where we have problems.
If I say obi on my birth certificate now and this could be a problem.
You see, it's a birth certificate, Ayira Jones, for example. If you have a copy, that's brilliant. But if you don't, you need to remember, it's going to go through the biometric system again. So it's going to be like a new birth certificate as opposed to it being just another copy of the old birth certificate that you had. So definitely, the entry clearance officer, well, not definitely, but they can query it. Last month, now I could a birth certificate. And we'll try some immigration advantage. And I said, but there are ways and means around it anyway.
Okay. Bit me up for 0203-735-8820 or 0203-286-0185. Mobile line is 0778-793-9958. There are ways around it. Why you write a birth certificate. Now we'll go through the new biometric system now. You need to be able to explain, and when it comes to immigration issue now, and both team and say, "Well, to me, I answer." Into Bomodian say, Abinelle Solicitors. Why? Bomodian, one more office line, 0203-759-3309. And also with me, one more mobile number, 07824 705-353. And then Abinelle Solicitors, one more mobile line, and then one office line. Now be to me, my friend. Now, on the subject of divorce, because my specialty immigration law and family law, mediation for divorce, financial orders, and child arrangement, and then so.
Yes. Okay. So, Jones, with this, of course, a lot of the times, it's about divorce, about financial orders, and I say, call for child arrangements. There's always there could be some form of dispute or some form of maybe disagreement or, a breakdown in relationship somewhere. Okay. So, in terms of mediation, I feel so in mediation, a with each and every aspect of these areas, because there are advantages to it and there are disadvantages. For starters, the family court would always wish for alternative dispute resolution to be used before you come to the family court. So they will always want you to try, resolve the issue amongst two of you or amongst the family amicably before say a court, But apart from that, there are some key advantages. Okay, for example, let's take it one topic at a time. Let's take child arrangement orders. That is, in respect to children, the arrangements for children when, for example, there's a breakdown in the relationship. As you know, both parents, maame ne papa ne nyaa, omo nyaa no, omo pese omo ho akola no. Baako be pese one nkola no betina. Baako nso be pese one nkola no atena. Ana se baako nso be kase, okay, me ne nkola no ntina mo ba me pese me hu me mba. Omo ye me mba. Nti me pese me hu mo. So where mediation comes in to help the situation, where there's a breakdown in relationship and both parents are very caring and they want to be actively involved in the children's upbringing, you look at the advantages to using mediation. In respect to child arrangements orders, before you even get to the point of even, getting to the court, you are obliged by law, you have to go through something called a MIME, which is a form of mediation before the legal process begins, okay? So what are some of the advantages? Because some parents they'll say that, well, it's a complete waste of time. I really don't want to go to court. I don't want to have to do any mediation. I just want to see my children. Some will just say, listen, I'm so angry at the situation that I don't want to even see the person. I don't want to even negotiate with the person. It's non-negotiable. I don't want to do so. But I would tell you, Jones, that viewpoint, we are parent into boyfriend, because relationship, not saying, we really need to take that out of the equation. In respect to child arrangements, we have to realize what the overriding objective is. The overriding objective is to make sure, say, in Kolano, come first, the welfare of the children. Into in Kolano no more share, and yet more parents now, more boyfriend gidi debi, or more share in Kolano. First and foremost, the welfare principle, right? Right. So putting all of that aside, Jones, if you look at child arrangements and the mediation process, which is a MIME, if you look at it, some of the advantages is, for example, the process is, well, in this case, is not really voluntary. You have to do it before you go for a court hearing, but it's very flexible. So one party can initiate the process, and even if another party is not willing to be involved in it, it's a very informal process that brings both of you together. Remember, if you're doing mediation, people have the opinion that you have to meet your ex-spouse or your ex-partner. With some of these mediation companies, what they do is, ex-partner, they'll do it on Zoom with individually, and they'll try and come to a point in which there's understanding and come to a point where things can be resolved. So it's not an opportunity to meet your ex-partner and start with all the horrible things that have happened, but it's a chance for somebody, a middle person, to help, resolve your disputes. So that's one advantage. It saves a lot of money and time. Jones, child arrangement orders, once all issues in a relationship, it breaks down. Na in kolaka. So court. You have to remember, say, and it's very expensive. So this is an alternative way to cut down the cost, Jones, to keep the cost at a bare minimum so that you can save money. Also, Jones, say a quarter, and there's so much involved. There's allegations of harm to the children and so on and so forth. we have to remember that the officer of the court, CAFCAS, will get involved. There will be a first dispute resolution hearing, and there will be interim hearings, subsequent hearings before it even gets, there may be even a fact-finding hearing before it even gets to the final hearing. So it's a long process, long-winded process, which involves a lot of money. And I think that it's very important that the listeners today, listening to us on air and on Facebook, we should all remember that going through the process of child arrangements is very expensive and is time-consuming. With mediation, on the other hand, it saves time because you come together, you both bring your views on board, and they try their best. For you guys to reach equilibrium where both of you agree. And it cuts down all of that court time, the court time that you spend going to court, trying to resolve the dispute, it cuts it down. Also, we have to remember that mediation is far less, costly than going to court, because court, with every hearing, you're being billed, or you have maybe barristers who are going to represent you. So it's more expensive. This is a very cost-effective way of resolving your disputes. Importantly, Jones, before I round up this topic on child arrangements, it preserves relationships. That's so important. When there's problems within a relationship and there are children involved, for the sake of the children, you want to make sure that you preserve your relationship so that you can both jointly raise the children and make sure that their upbringing and development is of the utmost sort of importance. But sometimes going to court, it takes that away because it is litigation, it is some form of litigation. It's a court process, okay? Albeit not like another type of litigation, like maybe a contractual matter or a land matter, but at the same time, it's a court process. So sometimes, Jones, going to court alone, it can make people so upset that it can destroy the relationship completely. So I would always say that mediation is one of the best ways of resolving your disputes. When it comes to children matters, is very important that you actually use the mediation. Jones, let me say mediation, who say with a lot of people, say your friend and say, okay, mediation, it's time to mediate. Into mumbra na resolve the issue. No. What me say another party, no, but that is the key way of actually preserving the relationship, saving money and saving time as well. That's one of the key ways of doing that. So let's go for mediation in matters like this. I think we'll discuss divorce and financial orders as well, but mediation is probably the best way. There are some disadvantages of using mediation in these areas. Some of the disadvantages is that the parties have no access to legal aid. So you're going to pay for the mediation process to be conducted, right? The mediator may not be an expert in family law, so they may not know a lot about divorce. They may not know anything about child arrangements or financial orders, but they will try to just bring you guys together to reach a conclusion. That can also be a disadvantage. And the process also can be considered informal. Some people, if they want to resolve a dispute, they want it to be a formal process. They want to see a judge, somebody who's legally trained to help them make the decision concerning the children or their divorce or their financial order. In mediation, you won't get that opportunity to be in front of an impartial judge. So those are the disadvantages associated with mediation. But yeah, Jones, if there are any questions that anybody needs to ask, whether on air or via our chat, please do feel free to ask, because I'm more than happy to assist everybody with their queries.
I've got a text from Alice. Alice is saying that she got a molestation order against her husband.
Okay.
She's filed for divorce, just waiting for documents to be sent. And then she goes on to say that she moved out of the family home to join her parents. Upon several discussions with her family, she decided to give the husband access to the children. However,
Okay.
in his current position, she doesn't feel as though that he's in the best financial position to look after the children. And
Okay.
moreover, the children have complained that he has been beating them in a way to try to discipline them, where um, her son actually went to the school to report that the father beat him whilst they were going to school. So
Okay.
Alice is asking, um, should, if I decide to take the case further, would there be any, would I be reprimanded for allowing him to see the kids, as I took out a molestation order against him in the first place?
Well, yes. I mean, if there's a non-molestation order in place and that's been breached, normally it's normally the respondent that sometimes breaches it. But if the applicant has breached it, but there's good cause to do so. So maybe if you've settled matters amicably and you now feel it's right that the children see their father, then yes. I think with you being reprimanded, really it really just depends. It really just depends. But I don't think so. You know, you've tried to settle the matter. That's why you allowed him to see the children. However, Jones, I think what Alice should be aware of, it depends on the severity of sort of the molestation against herself and the children. If it was something that has been reported, and of course you've given witness statements and completed the forms for non-mol, and you've let them know how serious it was. Maybe you may have even had some evidence, medical evidence, and you've told them, they would expect that before any of this is done, before you allow the father to see the children, you allow, it should either be through mediation, but even in this case, because there's domestic violence, it should really go to court, and for the CAFCAS to get involved to fact find and find what is actually happening with the children. So it really depends. I would really appreciate it if Alice could give me a call so I can get a much clearer picture of what's happening, and then I'll be able to advise her accordingly. But yeah, it's a very dicey issue here. She obviously wants to do the right thing for the father to see the children. But on the other hand, if the children are being abused, she also, wants to put on the protector hat. She wants to protect the children as well. So please let her give me a call. Let's give her the office line and my mobile for her to contact us, and then we'll book an appointment for her to come and see us.
Okay, so Alice, this is the number 0203 759 3309. 0203 759 3309. That is Abinelle Solicitors one more office line. Mobile number is here 078 247 05353. 078 247 05353. As no obetimi afre. I got a message here from William. William is asking, can he marry his girlfriend from Nigeria? She hasn't got her papers, but he has. Does he have to go to Nigeria to marry her, or it can be done here?
Okay, so girlfriend is in the UK.
Yes.
Okay. Jones, what I'll say to William is, with spouse applications, it's an entry clearance application, especially if you don't have immigration status. So in the country, you're an overstayer, for example. However, there may be other aspects to the case that may allow them to eventually get married in the UK. For example, maybe if they have children together, or William has children from a previous relationship, and she's very much involved with the upbringing and development of the children, then it may be, it's not definite, it may be that we can look into making an application outside the rules. So again, if William can kindly give me a call, I would also want to know how many years she stayed here illegally to find out whether she qualifies under any other avenue as well, and then I can advise accordingly.
Akushi, another text from Akushi. Akushi is asking, is there any update on Zambrano?
Yes. As at the 13th of July, the Home Office, they really gave a response to the Court of Appeal case in Akinsenya. And it was quite straightforward. What they said is they're not happy to allow Zambrano carers or carers of British citizens who have done 5 years with limited leave to remain, right? They're not happy for them to then apply for indefinite under Appendix EU. They're not happy with that because they feel that under that route, you should have started with the Zambrano derivative right. You should have been, an applicant who already was on that route for you to qualify under Appendix EU and apply for indefinite leave to remain. So that would be people who had derivative right and who were given 5 years initially. They've now said that anybody who had limited leave to remain under something like Appendix FM, so they were on the 10-year route, they're not going to allow them to circumvent that, just do a quick 5 years and then come and apply for indefinite under the Appendix EU route. So they've made it quite clear now that is their position. With the Court of Appeal, the courts, handed it over to the Home Office to really come up with a solution as to whether people who are Zambrano carers, people who are carers of British nationals under the 10-year parent route and the Appendix FM, for example, can apply under Appendix E. But they're saying no. They're actually saying, no, they won't allow it if you have limited leave to remain already, which means that you would have to continue under your own route, which is maybe the 10-year parent route, 10-year private life route, really the 10-year parent route in this situation. But yeah, so we should be very careful as to how we go about things. Of course, the courts have said that it's not right that they would have to be on that route for a 10-year period if they're British carers of British nationals. However, the Home Office have set the pace and have said what they consider will happen in respect to those applications. So as I said, it's not something that you can't appeal if you get a refusal decision for doing it under the Appendix EU, but you have to remember if you're putting in an application, this is the Home Office's stance on people who are on the 10-year parent route. They're not going to allow it. They're happy to refuse it because they feel that you should have been under that route, derivative right, in the first place. So I think if you have any further queries, I think you should definitely give us a call on our office line and we can discuss with you, book an appointment. If you've maybe got a refusal decision, maybe we can help with an appeal process. So please do give us a call and we'll be of great help.
Okay, number here, Abinelle Solicitors office line, 0203 759 3309 0203 759 3309. Now mobile number is here 078 247 05353 078 247 05353. I've got another text message here for you. I'm just trying to get it up. Right. So this is from Mami Adra. Mami Adra is saying, I quote the tail end of the fee waiver. Please, can you explain what the fee waiver is and who qualifies?
All right. Jones, the fee waivers, of course, firstly for in-country applications, because I don't know which one she's referring to, but now, of course, they've introduced fee waivers for visa applications, certain human right visa applications as well. So fee waiver in both aspects, both for visa applications and for in-country applications, the standard test that you need to meet is the affordability test. That is what you need to meet. So, Jones, when we say affordability, it doesn't mean that, oh, because you're earning £2,500, or maybe your household monthly income is £7,000 or £6,000, that means that they won't grant a fee waiver in your favor. It's not true. It doesn't work that way. The way it works is, although you have your income, your monthly income, can you afford to pay the fees? That's a very important question. So you can have 7,000 between you and your partner, £7,000 household income, but you cannot afford to pay the fees. One, because, for example, maybe you don't have savings, and if the cost of the fees is exorbitant, you don't have that money to settle the fees. Two, we always do an income and expenditure to give the visa entry clearance officer a good picture, or the Home Office representative a good financial picture of what's actually happening in respect to your finances. So we look at your income, and then we look at all your outgoing costs. So she should remember that when looking at fee waivers, we are looking at your income, your outgoings, and possibly any other sort of savings that you may have, any other income that you may have. And we're looking to see, when we bring all of that together, can you afford to pay the fees? Can you afford to pay it? Or not only immediately, but within the last 6 months, have you had the means to afford the fees in question? Because, Joan, some people, they spend, lavishly, they're spending lavishly. Some people, they spend carelessly, they gamble. Maybe they spend money on things that are not for their essential needs. And then it comes to the point where they have to make their application, and they want the Home Office or the Visa Entry Clearance Officer to just grant it. And that's where they come hard and strong with their Home Office guidance and what it says. You can't, just squander your financial resources and then come to them for a fee waiver. They want to see your financial conduct within the last 6 months, what has come into the account, what you've used it for. So if you have, let's say, £2,000 coming out last 2 months, they're going to query you, what was that money used for? Because, of course, that could have been used towards the fees.
All right. So, Amy, I would like for you to switch off and switch back on of the Zoom. And whilst you're doing so, so we're still talking to Amy. We're here till 11 o'clock. Keep sending your messages in, and we will put it to Amy for Amy to read them. It's just that Amy just needs to switch off and switch back on,
Yes.
and then we'll have it on again. So before Amy comes back on, let me put Abinelle Solicitors address so that you can go and see them. So the address is 14 Claypole Road, Stratford, East 15, that's E15, to RJ, Romeo Juliet, to Romeo Juliet. And the office line is 0203 759 3309. 0203 759 3309. So for one more mobile number, this one, 078 247 05353. 078 247 05353. It's no fret one more on Sabeka Omona or the questions in Amamo. Na woman so enya kwan aboa enti no ment na no mo and think say obi etimi aye ne de enti no won so obetimi aye the same thing. Don't sit there and do that. Amy, welcome back.
Hello.
Text message back one. The person says, I have limited leave to remain. How long can I be out of the country for? Because I want to travel.
All right, limited leave to remain. Obviously, that we have to remember that for future purposes, you need to apply for your indefinite leave to remain, your nationality as well. So you don't want to be out for more than sort of 90 days. Really, I think for me that would be really the cap. 90 days, and then also Jones. For some people who are on the parent route, what you've said is you have 10-year parent route or 5-year parent route. What you some of the submission that may have been made is that you have a sole parental responsibility for a British child or a child with limited leave to remain, or a child with indefinite, or the child has British nationality. Now, if that be the case, if you're out of the country for a very long period of time, Jones, it sort of begs the question: Are you looking after a British child in the UK if you're out of the country for 6-7 months at a time? So that's for the parent route anyway. And same with sort of the partner route as well. Out of the country for 7-8 months, you're married to a British national. What begs the question is, what do you call it? The immigration officer can always ask you, well, I thought you're married or you're in a relationship. How comes you've been out of the country for so long? One of the requirements is that you're in a genuine and subsisting marriage. So to be out of the country for so long, your partner's somewhere and you are somewhere, that can, of course, raise flags when you're coming back into the country. So these are questions that you may be asked.
All right, now let's move on. Let's look at misrepresentation for visa applications and home office applications.
Yeah. So, Jones, this is such an important area, and often we get it wrong. Metimiaka said with visa applications, there's going to be quite a high percentage of NIPA application misrepresentation kahon, and I say fraudulent documents and so kahon. I think it's very important. Say Nemeka said, "Oh yeah, visa application." Now, who dream say with your knowledge as a lay person, who dream say how we the emfa bank statements way in kahon. I say mitimi tra na scanner also. I say yehiam. Into me the fraudulent bank statements come me documents home. Abwa immigration process no. Jones, that is a big no-no, and it's never something I would tell somebody to do, because there's so many ways around it. I mean, it might be that you're a business person and you have capital and you are using it to run your business. So you have money coming in, money going out, and that is why on some occasions there's more money than other occasions. So there's always a way to explain yourself than to try and go and get fake documents in support of the application. So I would always say that uyo bia upesa oba kromha, and now a relative bia upesa oba and na e bakra what na hache upesa oba won chain visit to kromha. Ufili say so on university and also on school so a fake document, a fake certificate in support of that application. To be honest, Jones, it's all going to end, you shouldn't lie to the Home Office, neither should you lie to the entry clearance officer. If you do, if you tell lies, if you do provide fraudulent documents, it's a ground for refusal. It's a ground for, they can refuse you. And remember, when they do refuse you, they can also give you that ban as well, that 10-year ban, for misrepresentation, or 10-year ban for providing fraudulent documents, So we need to be very careful. As I said, there's always a way around things. There's always a way. Sometimes we need bank statements. You don't have good bank statements yourself. You are coming on a visit to the UK and you feel like money is what's going to, pull your application through. That is a misconception anyway. It's not money that pulls your application through. It is definitely a misconception. Of course, they want to see that you have money for your onward journey. They want to see that once you come to the UK, you'd be able to provide yourself with accommodation, and all your other essential needs. So you should have that money, that money in a designated account. That is fair. But they are not saying that you need to have millions or hundreds and thousands of Ghana cedis or pounds to prove that you can come to the UK. That's not what they're saying. So it's not your bank statements alone that's going to get you to the UK. So you might be in a situation, for example, I've had a client, what situation one, or using a bank statements, GDC scanning doors. But there was an alternative. You could have a third-party sponsor, financial sponsor, somebody a statements. It could even be your employer. It could be say employer or sponsor or abakroma the bank statements. It could be a family friend or a family member who says, instead of you can use your bank statements, in support, just to show that you're being paid, you're a salaried person, but also I'm going to use my bank statements to cover you, to show them that when you come to the UK, you're going to have food, all your essential needs, travel is going to be covered, and they can even provide you with evidence of their accommodation. So, as I said, there's no need to falsify bank statements or falsify documents. If you're not a university graduate, don't say you're a university graduate. The UK have opened their doors to anybody who satisfies Appendix V. Anybody who satisfies the requirements, they'll open their doors to you. So you don't have to be a certain kind of person. You have to be educated. You don't even have to. Your English does not have to be the Queen's English, or you don't have to, as I say, lie about anything. You just have to meet the rules. And at Abinelle Solicitors, what I can assure you is that we will ensure you meet the rules. You definitely meet the rules. Again, with Home Office applications, so this is to the people who live in the UK and are making applications. For example, if you're a spouse, you try and get fake utility bills because you want to prove to them that you've lived in the UK together with your partner for 2 years. You try and get fake utility bills to support the application. Jones, that is all wrong. Again, that could have an adverse effect on the decision and on your immigration history period. Okay, so I think there's a way around that. Maybe you don't have utility bills, but you can explain it in submissions. Sometimes, Jones, as you know, if you're renting a room, sometimes you don't pay utility bills. Sometimes it's all inclusive. So you give them a tenancy agreement that states it's all inclusive. There are ways and means to get around misrep and fraudulent documents. So as I said, Abinelle Solicitors, we are happy to be honest with you and to tell you what you need to do to make sure you make a valid application, an application with very good supporting documents to make sure your applications are successful.
And I think it's important, as you've mentioned, the trust and honesty, because at times you do come across some solicitors that they're incapable of getting your documents for you or helping you out, but they just sit on your case and they just prolong things. So do make sure you get in touch with Abinelle Solicitors. On the subject of education, there's a text that's come in for that, but there's also a message on Facebook. This is from Nana Berlin. Nana Berlin is saying, "Hi, lawyer. The loser paid the cost concerning child arrangement order." I think they're trying to ask, does the loser pay the cost concerning child arrangement order?
Right. You see, let me explain this properly.
But I think before you do so, it's worth letting our viewers or our listeners know that if you're listening on Tunein, we're about to end. Okay, we're gonna cut the show. Well, not cut it, but we're gonna go on advert. But the conversation still continues on our Facebook page, GN Radio UK. So you can swiftly just cross over to our Facebook page. Amy.
Thank you, Jones. So yes, Nana Berlin, in respect to family law cases, there's never a winner or a loser, especially with child arrangements. As I said, it's the welfare principle they look at. and they're looking at the overriding objective, welfare principle. So they're not saying, it's not as such, with some civil litigation cases, they could say that the loser or the losing party, whether that be the respondent or the applicant, or even in an immigration setting with the appellant and the respondent, if of course it happens that the appellant wins, then it means that respondent has to pay maybe court fees or pay for the cost of litigation period. But with family law, it's not like that. There's no losing party or winning party in this case. It's specifically for the children. So if it happens that the child arrangements is in favor of both parents, the court will not penalize one party and ask them to pay pay for costs. No, they wouldn't do that. So it's not like the adversarial sort of court process. So other things like civil litigation, maybe for example there are damages, there's loss of income. So and then obviously the time and cost it takes to go to court, everything will be lumped together, and they'll order one of the parties, the losing party, to pay everything. In this case, it's the welfare principle. It's about the children. So there's no winner, there's no loser in this case. It's just about making sure that the children, their best interests come first. So they wouldn't let any of the parties pay for costs.
I think this is probably going to be our last message. This is from Elizabeth. Elizabeth is saying that she's coming to the end of her undergraduate degree. However, she would like to stay in the UK and work. Is this possible? And if so, what is the process?
Right. Very good question, Elizabeth. Yes, there is a chance for you to work. They've introduced the graduate visa, which allows you to apply once you've successfully completed your undergraduate program or postgraduate program. Allows you to apply for a further 2 years visa. If you've undergone a PhD, 3 years, and gives you the opportunity to stay on with that graduate visa. So once you get, for example, your undergrad, once you are given a graduate visa, and for 2 years, you can either choose to work with that visa, or you can choose to study on as well. So there's a lot of flexibility, and that's an excellent initiative for undergrads. So please, Elizabeth, give us a call. You definitely have a chance to stay in the UK and work. Also, she can also apply under the skilled worker route, depending on what she is actually, what sort of work she's into. So that's also a possibility as well.
Okay, time is fast spent. Amy, as always, a pleasure to talk to you. Thank you very much for joining us this morning.
Good morning.
Thank you. So that was Amy from Abinelle Solicitors. Let me quickly put the details on again. So let's begin with the phone numbers. All right. So everyone that we've spoken to you or you've sent in a text, the ones that are listening and are unsure, the area of specialty where they deal with the areas they deal with immigration law and family law. The mobile number is 07824 705353. 07824 705353. Alternatively, you can call the office line on 0203 759 3309. 0203 759 3309. So do make sure you give them a call. All right. Don't just sit on it and just wait and, hoping for a friend to help you or to assist you. Make sure you get in touch. Abinelle Solicitors, their address is 14 Claypole Road, Stratford, E15, that's East 15, 2RJ, 2 Romeo Juliet. Okay. Make sure you find your way there. And Abinelle Solicitors are there ready to help you. Amy did touch on one thing which I think is very important, and we must also address this issue. A lot of the times, and I've come across many, lawyers who will tell you what you need to hear and fail to deliver. Abinelle solicitors are not like that. Go and see them, and they will help you. You've heard them talking on the platform. This is a firm that you can have faith in, and they'll be able to help you. So I know some people have had bad experiences, and some have vowed not to deal with, lawyers from our community. But don't let somebody's inability to help you overshadow the ones that are actually out here doing work and helping the community. So do take note of that. We're done for another day. All being well, we'll be back here next week. Until then, look after yourself, and we'll see you next week.